And welcome back. Close this door here. So we're going to talk about a chapter that is essentially about diversity. And we got a lot to talk about on this one. I know that it's not possible to talk about everything within a 1 hour, 2 hour, even a couple day lecture on this very, very vast and important topic. But we'll give you at least some of the basics, and at least you can build on them in your other courses. So the first thing we want to talk about with diversity, and I kind of like to give this as an example, is talk about protected classes. Okay, and protected classes, I think, are an interesting indicator of exactly how diverse a population can be. So protected classes, you basically, of course, as you probably know, you cannot discriminate against anyone based on their membership in a protected class or protected group. And so let's talk about some of those examples. Some of these you probably know about. You cannot discriminate based on race. You cannot discriminate based on color. You cannot discriminate based on religion. You cannot discriminate based on national origin. You cannot discriminate based on age. Okay, so you cannot refuse to hire somebody just because they're over 40. You cannot discriminate based on someone's gender. You cannot discriminate based on their pregnancy status. Are they pregnant? You can't say, I'm not hiring you because you're pregnant. Citizenship. You cannot discriminate based exclusively on citizenship. Familial status. For example, are you single or married or things like that. You cannot discriminate based on disability, and that includes HIV status. That's considered a disability. You cannot discriminate based on someone being a veteran. And you cannot discriminate based on genetic information. I don't know if any of you saw that movie Gattaca. That's a good example of that. Now, of course, there's some exceptions around this, like a BFOQ, bona fide occupational qualification. Let me give a couple examples of how BFOQ can make things kind of difficult. If you are doing a TV commercial and you need a man because it's for men's shoes, you can actually not hire a female actor to do that job because you're talking about a man wearing men's shoes in a commercial. So that's a bona fide occupational qualification. Pregnancy can sometimes also be a discriminating factor. I've seen cases where women are not working in areas with high levels of radiation, again, because they're pregnant. Citizenship, you can in some ways. Certain jobs in the U.S. government require a security clearance. You cannot have a security clearance if you are a foreigner. So there is a way around that. Veteran status, again, in the federal government, typically veterans are given preferential treatment. Those are just some examples. Another example, for example, you cannot be a Catholic priest if you are not Catholic. Bona fide occupational qualification. There was one case in LA where a lady wanted to work at a Thai restaurant and she was not able to do it, and she lost her case because the owner wanted to have the authentic Thai experience and wanted to have only Thai wait staff, but he was willing to hire her for positions as a cook or as a dishwasher, but just not with customer service. One of the issues that I think is important to note here with protected classes is that these are all self-identifying. Okay? So I cannot say, well, you look like a certain race or certain religion, and therefore, no, I have to self-identify. For example, I am a veteran, but you cannot simply look at my service record and say he is a veteran. I'm the one who has to identify for you. Again, this is important when you're doing population reporting, quarterly status reporting. Quarterly status reporting is where you report the breakdown of employees based on typically protected classes. Again, it's self-reporting. And if you don't fill out the report at all, nobody really knows. So, employment discrimination has existed in the U.S. at least since the 1600s. Again, you think about things like indentured servants, you can think about things like slavery, you can think about discrimination in the workplace. It's definitely been around. And one of the arguments against discrimination is from John Locke, and that's natural rights. Okay. Again, people have a natural-born right not to be discriminated against. Natural rights in action. Now, the issue of slavery, of course, arose during the Civil War, and Lincoln issued this Emancipation Proclamation freeing the slaves that lived during the Confederacy. And after the war, Congress passed 3 different constitutional amendments to protect the rights of former slaves. And for a while it worked, especially during the period of Reconstruction, because the Union Army was there to enforce the protection of slaves. However, after the period of Reconstruction, once the Union Army pulled out, these laws were very laxly enforced, and it wound up developing into segregational statutes that we now know today as the Jim Crow laws. Now, in the United States, we typically talk about African Americans as a group that are discriminated against, or those descendants of former slaves. However, we've discriminated against everybody in the States. Native Americans, I mean, not only were they treated as inferior, we more or less eradicated their entire race, which, when Mexico ceded Texas, Arizona, New Mexico, and California, Hispanics became U.S. residents, and they were discriminated against, and still are today. Working on the railroad, Chinese laborers faced economic and racial discrimination. I remember reading a story that a Chinese laborer working on the railway made 25 cents a day for a 12-hour day, and an Irish laborer made $1 a day for an 8-hour day. And of course, early Japanese immigrants, particularly on the West Coast, were also subject to discrimination. Now, again, Congress did intervene after the Civil War to try to prevent some forms of racial discrimination, namely with the Civil Rights Act of 1875. Nonetheless, businesses still could make the choice to discriminate against former slaves. Of course, we do have the Plessy versus Ferguson case. Okay, this is a good example. In the Plessy versus Ferguson case, Homer Plessy, who was 7/8 Caucasian and 1/8 African, so somebody obviously knew he was of mixed race, was asked to move to a non-white coach. Okay, this is segregation. And again, Plessy refused, and he was taken to a jail. And he claimed that he was not being given equal protection under the law based on the 14th Amendment, and the Supreme Court disagreed with him. So they came up with this separate but equal doctrine. Now, of course, if you look at the separate but equal facilities, they were separate, but they were far from equal. If you looked at the white facilities, they were usually very nice, clean, maintained. If you looked at the African American, everybody else facilities, they're usually pretty nasty, and nobody wanted to really use them. And of course, the Plessy versus Ferguson verdict emboldened people all across the South, and Jim Crow became ever more rampant. And black workers continued to face discrimination, and these customs also spread to the North. It wasn't restricted exclusively to the South. Now, the Civil Rights Act of 1964 was a product of the Civil Rights Movement, and you came up with Title VII. And Title VII creates the Equal Employment Opportunity Commission, which is an important aspect in this chapter. Title VII basically stated that employers could no longer engage in outwardly visible displays of discrimination, which is great, right? Unfortunately, in the early days, there weren't any real weapons to actually fight that separate fact. And I am looking at our time, so I'm going to stop here, and then we'll pick this up in the next video.